Hi, everyone. I'm Branden. Welcome to another LSATMax national webinar. Thank you for joining us today. Today, we are going to be talking about a range of things. We're going to be talking about the hottest of hot topics in the LSAT, in law school, and in the legal profession. So hopefully there will be some useful information for you in today's presentation. A few things before we get started. One, this presentation, like all of our presentations, is one that invites participation. You can participate in a couple of different ways. If you have a question or comment, you can type it into the chat box. These are all options that are available at the bottom of your Zoom window. I know we've all been in Zoom school forever, so I'm probably not saying anything that anybody doesn't know. But feel free to type questions or comments into the chat box. I'll try to keep an eye on it. In a big presentation, the chat box sometimes goes by a little bit quickly, so I might not catch what's in there. We also have our marketing manager, Katie, with us. She's awesome, and she is going to be monitoring the chat box, I think, so she can answer the questions that are about the course and things like that. There's also the option to raise your hand. I can call on you. You can talk to everybody just like I'm talking right now. There's also a Q&A box. If you have questions or comments that are not quite on the topic we're talking about at any particular point during today's presentation, feel free to drop your questions into the Q&A box, and I'm happy to answer them. Just so you know my experience and kind of the range of questions I can answer. I graduated from, well, I took the LSAT and got a 175. I graduated from UCLA School of Law in 2011. I practiced patent law for a couple of years. Obviously, I passed the bar exam in there somewhere. So if you have questions on any of those topics, feel free to ask them. So I think that is the housekeeping that I have. So why don't we jump in? I will share my screen with you and we can talk about what's going on in the legal world as we speak. All right, here we are. So first of all, let's talk about the LSAT and what lots of people have been very unhappy and upset about recently, which is the LSAT getting easier? Is there score inflation? It seems like if you look at some of the numbers that are released by LSAC, the Law School Admissions Committee, that scores have gotten higher, and specifically in the last year when applications also, increased in volume, that there were a lot of people with higher scores. So what people have interpreted that to mean, which it does not necessarily mean, is that more people or a higher percentage of people are doing well on the LSAT. That should not be the case because the LSAT, and although it's very complicated, the LSAT is scored on a curve. I think they call it test equating, and there's a lot that goes into it. It's not just a standard curve. But the idea behind it is that just like any curve, a certain amount of people are going to get certain scores, and it goes from there. So like in law school, if you're on a curve, a certain number of people are going to get A's, a certain number of people are going to get B's. So why does it look like this? First, let's have a look at what is making people think that there is score inflation and talk about maybe what is actually going on. And we don't know entirely what is actually going on. The thing that is kind of hard to figure out, or the thing that is hard to understand, is that LSAC does not just release dumps of information about all the people who take the exam. Instead, what we get is information about people who actually use their scores, people who go on and apply. So they don't give you information about scores in general. Instead, they talk about applicants and applications. So one applicant can send out many applications. And both of these have gone up, applicants and applications. And LSAT scores have gone up dramatically within those ranges. So I'm not going to get to all of the different ranges of scores, but at the very top end, 175 and up, in this last year, in the year to enroll for 2021, 175 plus scores were up 103%, meaning more than twice the number of applicants with 175 plus scores were applying. And sub 140 scores, the scores at the bottom end of the chain are down. They're down a little bit by 7%. So what people think when they see this is, aha, the LSAT has gotten easier. It's easier to get a 175 plus score than it was before. Again, that's not necessarily the case, but let's talk through what has happened, and then we can kind of speculate, and I know that we're not supposed to speculate as future lawyers as much as possible. That's actually an objection you can make in court, but we will speculate a little bit here. So last year, total US applicants, the number of people applying for law school rose by a very impressive amount. It was up 13.6%. In the year to enroll in 2020, 62,303 of your fellow human beings applied to law school. Not surprisingly, because we had the pandemic and a lot changed in our economy, and a lot of times when there is chaos in the economy, people go to law school because it's a shelter. Enrollment year 2021, so people applying and enrolling, the people who are starting at law school now, or in the next few weeks, the people who are starting generally in August is when law school starts, that was up to over 70,000 people. So that is a large number of applications. We don't know what 2022 is going to look like. I'll talk about that in a little bit, but 2022 is very mysterious when it comes to predicting what's going to go on in law school enrollments. And we're actually going to see that 2022 is also going to be kind of a crazy year as well. So that said, even though total US applicants was up 13.6%, total applications was up even more than that. So there were more people sending out applications, and each one of those people sent out more applications. So in enrollment year 2020, those 62,000 people sent out 382,000 applications, which is about 6.1 applications per applicant. In the next year, that number went up a lot. The average didn't go up so much, it went up to 6.7 applications per student. But all of this makes it harder. So not only are there more people applying, but each person is sending out more applications. So does that mean, and let's circle back around, does that mean that this statistic, 175 plus and up 103%, does that mean that the LSAT has gotten easier? It is possible. Like I said, the makers of the LSAT are not releasing this information, so we kind of don't know. But what we think happened, or what accounts at least for some of this score inflation, is that when there are more people applying, it gets more competitive. And so the worse your application package is, the less likely you might be to try to go out and apply to a law school. So when it comes to all of the test takers, some of them are going to go on and apply to law school immediately. Some of them are not going to apply. And then some of them, and here is what I think is actually accounting for a lot of this, some of them will have that score in their back pocket and they may or may not apply later. And I think one of the things that drove this incredibly competitive application period is, I think a lot of people who had some of those very elite LSAT scores, those 175 plus LSAT scores, had jobs that probably were satisfying for them and that were paying them a lot of money, and they didn't really see a need to use that LSAT score. But you can use an LSAT score. Almost every school will take a score up to 5 years old. So I think a lot of people, especially those who got laid off at the beginning of the pandemic, thought, well, okay, now I'm going to put this 175 score to use. So more people with those impressive application numbers were applying. And I also think that a lot of people, or at least some of them, who didn't get good scores on the LSAT just decided it is not worth the effort and the expense, because it does cost money to apply to law school, to apply with these numbers. So it may be that the LSAT has gotten easier. It may be that the curve has changed. The makers of the LSAT claim up and down that that is not the case, that the lsat-flex, which is no longer a thing, we're going to talk about in a moment, the real LSAT has come back. But the makers of the LSAT say the LSAT is just as difficult to get a high score on now as it was before. So do I have the absolute number of 175 plus? I do not have that absolute number. It was not a huge number before, but it's more than double whatever that number was. It's always going to be a small percentage. But what that means is that, you know, schools like Harvard and the other top schools, Yale, Stanford, they were just overwhelmed with people who generally meet their criteria. But I do not have the absolute number. So that is as much as we know. again, we kind of don't know what next year is going to look like. I'm going to talk about it in a little bit when we talk about law school. But I do think that next year is going to be competitive again. I think it's going to be very competitive. I think it's going to be competitive for different reasons. I think it might not be as competitive as this past application season, but I do think it's going to be competitive. So that's what people have been worried about. I'm sorry I don't have an absolute answer as to whether or not the LSAT has gotten easier, but I don't think it has, or at least not much easier. What has happened, as the world returns to normal, nature is healing itself, the experimental section is back. So if you signed up for the LSAT and took the LSAT anytime within the last year or so, you took the LSAT-flex, which was a much reduced version of the LSAT. The regular LSAT is sort of kind of coming back. It's sort of kind of coming back in that it will have an experimental section, which the regular LSAT had, and the LSAT-flex did not have. The ways that it's going to remain how it has been, at least for a while, is that at least until June 2022, so for almost the next year, it's still an online live proctored format, meaning you will be taking the exam at your home on a laptop or a desktop computer. In the year or so before the pandemic came around, the LSAT had transitioned from a paper and pencil exam to an exam that you would take on a tablet at a testing center. In June 2022, it seems likely that that tablet testing center format is going to come back, but we're not really sure. We just know that through June 2022, the LSAT is going to be in the same venue that it was and in the same milieu that it was as an LSAT-flex, and that you will be taking it at home. The LSAT-flex was really nice because, and this is where I'm going to give you my, I used to walk 10 miles to school uphill in the snow both ways story. On test day on the LSAT-flex, you had 3 35-minute sections. When I took the exam, there were 5 35-minute sections on test day. It is going to go back up to 4 35-minute sections on test day now that the experimental is back. What happened, or what is the difference between the LSAT-flex and the regular LSAT before, is that there used to be 2 logical reasoning sections that were scored. And then you would have 1 reading comp section, 1 logic game section, and then you would have an experimental section. Well, what they did when the LSAT-flex came around, or when the pandemic came around, is they said, we're not going to do the experimental section, and we are going to take away one of these logical reasoning sections. Well, as we are going back, the new LSAT has rescinded one of those things. In other words, you will take the experimental section now, but that second logical reasoning section apparently is never coming back. So it will be a 4-section exam on test day, although ultimately, eventually, to get your score, you're going to have to take 5 sections. So let me just explain what those are for those of you who are familiar with the format of the LSAT. I'll work through this quickly. But the basic idea is that there are 3 scored 35-minute sections. Those are these guys over here: logic games, logical reasoning, and reading comp. And then there will be on test day an experimental section, which is an extra one of these sections. So for instance, if on test day you get 2 reading comp sections, that means one of them was the experimental, although you will not know while you are taking the exam which was the experimental. If you get 2 logic game sections, one of those is the experimental. So what is the experimental? What is this section that does not count towards your score? Well, it's where the makers of the LSAT are testing out questions that will count on a future exam, but do not count on your exam. So what they want to see is a couple of things. One, how difficult is this question? Because they rate the questions by difficulty before they put together an LSAT. So how difficult is the question? And also, are people interpreting the question the way that they think it should be interpreted, or the way they're expecting them to interpret? So sometimes they will just, with a question, they'll just figure out, okay, this is the question difficulty. That's great. Let's move on. But sometimes they'll find out there's something wrong with the question and they have to change it. None of that really matters to you because it is an exam that you're going to have to take, and that experimental section is not going to count. So I'm saying in the Q&A box, what is the most common experimental section type? My understanding is that they divvy them up pretty evenly. So on test day, some people will get a logic games experimental, some people will get a logical reasoning experimental, and some people will get a reading comp experimental. It may be, and this is again me just guessing, that back in the day when you had 2 logical reasoning sections, since there were basically twice as many logical reasoning questions on every exam, that there were probably more logical reasoning experimentals because there were more sections that they were going to have to create out of logical reasoning. But I'm guessing, and again, this is speculation, but I'm guessing that as it stands, it's about even, because each test is going to have a section and they want to test them out. So the experimental is unscored. You will not know when you are taking the experimental. Now that there are 4 sections, there's actually a 10-minute break in between sections 2 and 3. So during the LSAT-flex, when it was just 3 sections on test day, you just got, I think, a minute break between each of the sections. But now you get a minute break between sections 1 and 2 and 3 and 4, and then you get this 10-minute break between the sections. There is also, and this has not changed for a long time, there is a writing sample. This you will do as a take-home exam, although the LSAT itself is now a take-home exam, and you will take it on a different day than you take the LSAT. It's not terribly important. It's not graded. It's not marked up. It's not commented upon. Instead, it is sent, your answer to, your essay answer to the writing sample is sent on to law schools without comment, and they can do what they want with it. So I think they do read them, especially if they're thinking about admitting you, but it is much less important than the other parts of your application package, especially your LSAT score. The thing is, because the makers of the LSAT want you to keep buying products from them, they have made it so that you can no longer get your LSAT score until you've taken the writing sample. So even if you take the LSAT, if you haven't taken the writing sample yet, they're just not going to tell you your score. And I don't know how to explain that other than to say the makers of the LSAT want your money. So that is what's going to be happening. Again, it is an at-home exam through June 2022, but starting this month, or next month, I guess, in the August 2021 LSAT, there will be 4 sections on test day, 1 of them experimental. That is our LSAT stuff. So does anybody have questions about the LSAT before we move on? We're going to talk about law schools. And this is also going to be information that's helpful to understand how competitive law school admissions is going to be. So what you may have heard of is that there is something of a deferral boom going on at law schools. So what is a deferral? A deferral is where you are admitted to a school, but for some reason, whether you want it, the school want it, both of you want it, you decide not to go to school that year, but instead you come back the next year and start. So people who are getting deferrals now, who deferred for 2021, will be eligible to start law school at the schools they were admitted to in 2022. Some schools, because this past year was a nightmare, over-enrolled. So schools do not just send out, if they have 100 slots, for instance, they don't just send out 100 acceptances. Instead, so Jesse is asking, yes, I believe this is just for US schools, these deferrals. I'm not sure what's happening in Canadian law schools specifically, if that's what you're asking. So schools don't just admit like the number of people that they have seats for, because a lot of those people are going to not take them up on their admission and go to law school somewhere else. So if you had 100 seats and you just admitted 100 people, you'd end up with a class of 50 people and 50 empty seats. So schools, including law schools, do something that may seem kind of reckless and dangerous, which is they let in more people than they actually have room for. Under normal circumstances, they understand about the rate that people are going to accept, put down deposits and come. And so they know, within a few students, how many acceptances they need to give out in order to fill up their class. And again, the number of acceptances they give out is larger than that number. Well, this year was a mess because lots of schools kind of were just working with information from past years about whether or not people were going to put down their deposits and enroll. And a lot of schools got burned for it because applications were up, but it is also the case that these people who were applying were serious about going to these law schools. So in some cases, and I think this one is kind of an outlier, but in some cases, they massively over-enrolled. In other words, lots of people put down their deposits and said, yeah, I accept your acceptance. I'm coming to your school, and they didn't have room for them. So Boston University accepts who knows how many people, But for about 250 slots in their 1L class, they got 415 deposits, which means nearly twice as many people as will fit into that 1L class are allegedly eligible to enroll in that class, and that is a problem. So that was a 51% increase in deposits, and unless you want to, expand your school by a lot, then you probably have to make sure that some of these 415 people aren't coming to school next year. UPenn, which is a really highly ranked great school, they over-enrolled by about 50 students. So some schools, and if you get admitted to one of these schools and you get this deferral option, it sounds awesome. Some schools have been paying students to defer. When I say paying, I'm doubting that what they're saying is we're just going to put this cash in your hand. So I don't think they're putting cash in people's hands, but they're paying students to defer. So Duke has offered $5,000 for students to accept deferral. So you've been admitted, we don't have room for you. We'll give you $5,000 if you'll just come back next year. Columbia, $30,000 for students to defer. That is a lot of money. My understanding is that it is a tuition reduction. So again, they don't put the cash in your hand, but law school will cost you $30,000 less. At Columbia, that may seem awesome, but I would point out we give another presentation about how much it costs to go to law school. And at least for the year that we created that presentation, Columbia by far had the highest advertised tuition. It was something like $72,000 per year. So even if you got this $30,000 off, if you accepted sticker price tuition, you'd still be paying $42,000 a year at Columbia. That said, $30,000 off whatever you were going to pay is good. A lot of people have been taking these deferments, so I don't know that these classes are going to be like catastrophically overextended. However, class sizes are likely to be bigger because a lot of people are not going to want to accept a deferral, and law schools are just going to have to, in some cases, expand in order to meet the extra demand. So is that a bad thing? Class sizes are bigger. Does it matter? It matters a little bit, and let me explain how it matters. Especially if you're interested in getting one of those big law jobs. So lots of people, they go to Harvard or Yale because they want to work at one of the elite firms, DLA Piper or Jones Day or Morrison and Foerster or Irell and Manella, because those firms pay $180,000, $190,000 right out the gate. Those firms probably are not going to be recruiting more people than they do normally. And in any case, those big firms, and this is where I think it becomes important depending upon what your goals are, those big firms tend to recruit people who are in like the top 15% of their law school class. So while it may not change, maybe they're still recruiting out of the top 15%. What that means is that there are just more people, and let's say 100 more people enroll at a school. Well, that means that 15 of those people are going to get into that top 15% likely. And then the other 85 people are not going to be there. So unless you're sure that you're one of those top 15% people, what this means is that you are less likely at the very least to get one of those big law jobs. And what that means kind of more broadly is that there is likely to be, I don't want to say a glut of lawyers. That's kind of mean because lawyers are people too. We don't want to talk about a glut of lawyers. But what it means is that in a few years from now, about 3 years from now, more people will be graduating into the legal market than they have in recent years. So it is going to be not just more difficult to get into law school, but I think it's going to be more difficult to get a job outside of law school. Maybe not by a lot, but it will be difficult. I think, at least in part because of these deferrals, 2022 is also likely to be competitive. So if 100 students, for instance, have deferred at Boston University, that means next year Boston University already has 100 seats taken. So you're competing for a smaller number of seats. I think it's going to take a couple of years for the kind of line to law school to shorten a little bit. That doesn't mean that law school is like impossible to get into. There are still over 200 ABA accredited law schools in the United States. And depending upon what your goals are, it may not matter if you're in the top 15% of your class anyway. So those are deferrals. Sorry to be the bearer of news that you probably didn't want to hear, but it is what it is. So law school, for those who are in it, vaccine mandates. A lot of schools have vaccine mandates, and most of the schools that have vaccine mandates, their law schools also have vaccine mandates, especially if the law school is on that same campus. There was recently a challenge in federal court. Some unvaccinated students sued Indiana University because they said they were being discriminated against, because Indiana University has mandated, with the exception of medical or religious exemptions, has mandated students, faculty, and staff to get a COVID vaccine before returning to campus. Well, I know this is a highly politicized thing, and people are, upset about this and a lot of other stuff, but vaccine mandates have been around for a long time. And if you go to most universities, they mandate other vaccines already. So mandating vaccines in general, I don't think is really something that is out of the norm. The vaccines for the COVID virus have not yet been approved by the FDA, which I think is why some people are hesitant about taking them. That said, there's very little argument, and I think this court case shows, because it was thrown out summarily, that schools cannot mandate people to have vaccines if they want to return to school. So like I said, often they have to offer religious or medical exemptions, but you have to show some kind of proof that you have a legitimate religious or medical exemption. A lot of schools, like I was saying, are going to have vaccine mandates this year, which means probably in the years to come, they will have COVID vaccine mandates. So if you're interested, for instance, in going to any University of California law school, UCLA, Irvine, Berkeley, Davis, Hastings, UC has a vaccine mandate. So you will need to have a vaccine to go to those schools. Other California schools, Stanford, USC, vaccine mandates. Big schools, Yale, Harvard, Columbia, NYU, all of the big boys have these vaccine mandates. So if you want to go to these schools, you're either going to have to get vaccinated, or you are going to have to come up with a religious or medical exemption that passes muster. So that's our law school updates. I don't think we have much more than that. Any questions on law school admissions in the coming year? That looks like a question we can do at the end. So let's talk about some updates in the legal profession. Yes, we are all a little bit farther away from practicing law than we are from the LSAT or from law school, but there are some interesting developments, and they will definitely affect you once you get into the legal profession. So I was talking about big law before. People like going to big law because they pay you a whole lot of money. And big law salaries are up. So the whole lot of money has gotten even bigger. It's now a whole lot of money. Some very important international firms have raised their starting salaries to $190,000. The kind of prevailing wage for the past year or two was $180,000. So Martina is asking, what do you think the 2022 cycle will look like for international students? I think it is going to be incredibly competitive for international students. I don't know that it will be more competitive for international students than it usually is, but it's going to be more competitive overall. And I think most law schools, they may set aside a number of slots for international students, but some law schools I know in their states have a requirement of accepting a certain number of students from their state. So the more impacted it is, I think will just make it more difficult for international students. But I don't know that it will look worse than it looks for anybody else. So like I was saying, very big law firm, DLA Piper, they're paying $190,000 right out of the gate. A lot of other firms have raised their salaries, but they're different for different markets. So if you practice in a big expensive market like New York or Chicago or Los Angeles, the starting salary in that market may be higher than another starting salary, but many of these big law firms are raising salaries across the board. And they're also handing out lots of bonuses, because even though this last year was devastating for some industries, it was actually not that bad for the legal industry. I'm going to talk about remote work for lawyers, but the legal industry is an industry that can work remotely, which I think has been helpful. If you want to make just the most money you can right out of law school, apply at Davis Polk. Their starting salary is $205,000 for somebody with very little experience just out of law school. That's awesome. Just to compare, the average lawyer salary, so this is not starting lawyer's salary, but the average lawyer salary, this includes people who have been doing this for 40 years, is about $145,300. So what that means is that in any of these big law firms, you're making more than the average lawyer in the United States makes right off the bat. So that's awesome. The problem is you work very long hours, and I guess everybody has to make decisions about what their time is worth. But let's talk about remote work for lawyers. So this actually, I think, is a bright spot in the legal industry. So I'm getting a question, why is Denton not considered top big law? I don't know if they raise their salary, then maybe they should be in here, but I'm not sure. I'm also getting questions, it looks like, on government jobs. So do you have any insight on the job market or salary changes in the public sector? Has competition gone up for DA positions? Those are, I think, similar questions because DAs are in the public sector district attorneys. I do not know if salary has gone up. I know those are things that are usually mandated either by a state legislature. So a lot of times state legislatures, depending upon the state that you're in, will change the pay grades. But what I would say is that I think those jobs will also become more competitive. They will become harder to get. So yes, when I got out of law school, I actually graduated right after the financial crisis, and I was looking for a job as a district attorney, and I was not able to find one because at that point, governments were firing people, they were not hiring people. The last thing I'll say is that my understanding is that state governments have actually done a lot better in terms of tax revenue than was initially thought at the beginning of the pandemic. So for instance, my state, California, we thought we were going to have a big budget deficit, but we ended up having billions of dollars in surplus. Just because the people who like pay the high-end taxes, those were the people who ended up keeping their jobs and making more money during the pandemic. So all of that is to say, if state governments have more money, then there are likely to be more state jobs and they are likely to pay more. I wish I had more concrete data for you on something like that, but I do think that's a bright spot. And so you might just want to check with your state. If your state is one of those states that's seen a windfall recently, then I do think hiring may pick up. But again, there are going to be more people applying for those jobs as well. So let's talk about being a remote lawyer. The legal industry is ostensibly really good for remote work. What lawyers do really does not require you to be in person, to be hands-on. Lawyers can do just about all of the work that they do in a quiet room with a computer and a telephone. Here is what you do mostly, and especially at the beginning of your legal practice, especially if you're working at a law firm, you're probably going to be doing a lot of this: legal research, writing briefs and memos. I will get to the Morgan Stanley thing in a second. I do not think they have their own law firm, but they do contract with law firms, and they are trying to dictate terms to them. But even the stuff that is like group work that you would do as a lawyer, it's still stuff that you can do remotely. So a lot of what you do as a lawyer is you meet with people, you provide them advice, you may seek advice from them if they are other attorneys. So you might have, if you work at a law firm, internal meetings with other lawyers. You might have meetings with the client. You might have meetings with the opposition when you are litigating a case. You might have meetings with the opposition and the judge is there too. All of these things are things that you can do remotely. The vast majority of courts in 2020 just went online. It did, my understanding is that in most jurisdictions, it ended up slowing things down. So cases take longer to process, and litigating a case can take 1, 2, 3, 4, 5, even more years to litigate a case. So things did slow down. I think a lot of that was that these courts didn't necessarily have the infrastructure that they needed to begin with to make this immediate and radical shift to doing everything online. But it was very common. I don't know if you saw that video from a couple of months ago with the lawyer who had used a cat filter and didn't know how to turn it off while he was at a court hearing, and he ended up just making arguments to the judge in the form of a cat. That was one of these things. So really, like, as an industry, the law should be very remote friendly because it is the kind of job that you can do, like I said, I think 100% remote. There is maybe, you know, something that you lose in a court case when you're not presenting face-to-face to the judge, or I mean face-to-face to the jury, or making arguments to the judge. But I think for the most part, it is transferable. That said, bosses tend to get to decide who gets to work at home and who doesn't. So a lot of law firms are being pretty flexible about it. Gibson, Dunn and Crutcher, which is a very big firm, they recently announced that their attorneys can work virtually at their discretion when appropriate, meaning they don't have any requirement that they need to come into the office for any particular thing. But when they say when appropriate, what they mean is that there are likely to be circumstances when it is not appropriate. So this is not a license to work 100% at home. What it is a license to make a decision about whether or not you really need to sit in traffic for an hour or two to get to a meeting that you could have, you know, over the phone or over Zoom. So that's great. However, law firms have clients, and law firms have to satisfy their clients. And some clients are very big, powerful corporations who can dictate terms to the law firms that help them. So Morgan Stanley, which is an investing firm, they're not a law firm, they recently made an announcement, their chief legal counsel, that they want the outside firms that represent them to be back in the office. So in other words, if you want Morgan Stanley's business as an attorney, you better bring all of your lawyers back to the office. A lot of people have pushed back on this, but again, a client like Morgan Stanley that probably has tens, hundreds of millions of dollars in legal fees every year, they can probably dictate terms to at least some firms. So if you are at one of those firms, even if your boss, the managing partner, decides that it's okay to work from home, maybe the client doesn't want it. There are also, and this is, I think, a burgeoning field, and it will become, it will get bigger as we go along. There are some Uber-style services, maybe Uber is not the best metaphor for this, but that connect lawyers either with clients or with firms that they can do like piecemeal work for those firms. So this is another way, you know, I don't know that transitioning to a gig economy is great. It's probably better for a lawyer who can make a lot of money in the gig economy than it is for, you know, somebody driving for a living or delivering food for a living. But I would imagine that these services have these same issues, which is that, you know, they take money and connect you, but they try not to be in the middle of the process. So that is one more way that I think work from home is coming around. So I'm getting the question, can you talk about foreign students who study JD joint degrees? I don't know that there's a difference being a foreign student to do a joint degree than there is for any other student to do a joint degree. I can just explain briefly for everybody who's here what a joint degree is. You can very often combine a JD, a law degree, with another degree. The one that is most common, I think, is a JD MBA, where you get a JD and a master's in business. But it usually ends up shaving 1 year off. So business school, for instance, is 2 years, law school is 3 years. If you were to do them separately, it would take you 5 years to get a JD and an MBA. If you do them together, it takes you 4 years to do JD MBA. There are other ones like JD Masters in Public Health. I remember, I think there's JD Masters in Social Work. I know there are some people who have a JD and an MD, which seems insane to me, but if you really want to have a JD and an MD, you can do that. Our last topic for the day, before I send you home, well, you're probably already at home, but our last topic for the day is artificial intelligence in the legal field. So the legal field is slow to adopt new technology. It is a very, I don't know if you know the word hidebound, but it's a very hidebound institution. The law has worked the same way, not just really for hundreds of years, but in some cases for thousands of years. It's old, it's been around for a long time, and the people who practice it don't necessarily like change. Just like every other field, though, the legal field is one where automation and artificial intelligence can be helpful. The area of law where computers kind of took over and shoved out the lawyers a long time ago is document review. So it used to be, as a junior associate, a lot of what you would do instead of doing legal research, which is a step above, is that you would just sift through the discovery that you would get out of the case. So when you are suing somebody or you are being sued, you have to turn over a bunch of documents relevant to the case. And then the opposing party also turns over a bunch of documents to you that are supposedly relevant to the case. What people often do is they'll turn over tens of thousands or hundreds of thousands of pages of documents. And a lot of times they know that most of those documents are not relevant to the case. And instead, what they're doing is burying the opposition in paperwork, which courts don't like, but lawyers still do. Document review is where, instead of having some poor junior associate spend the first 5 or 6 years of their lives sorting through these documents, is that document review scans the documents in and does a text recognition and understands the text that's in the document. And then you can search for key terms. And so whatever documents have those key terms will show up, whichever ones don't. So that's been around for a while. I think it's getting better all the time, and AI is part of it. But there are things that it seemed like were kind of jobs that only lawyers could do and would give you job security for the rest of your life as if you're a lawyer. And now those things are being encroached upon. So AI is in its infant stages when it comes to the legal field. But there are some really interesting developments. So let me just tell you about a few of them that I think are interesting. So a lot of what you do, especially like I was saying as a junior associate, is you do legal research. You look up cases and statutes that are relevant to whatever case it is that you're working on. And generally the way that you do that, there are these databases, they're great, but you do keyword searches. And so if you have the right combination of words, it may bring up the cases that are relevant. It may bring up some of them, but not all of them. And if you don't have the words that are relevant, you may miss the cases that are important. They may not come up. Well, what companies like LexisNexis and Westlaw, those are the biggest search engine databases for legal research, are doing is they're trying to use artificial intelligence to help people search for what they're really searching for, rather than just doing keyword searches, which they may be good at or bad at. So Westlaw has this beta function called Westlaw Edge. And the idea is that as you're searching, it's going to suggest other searches for you to do. And it also is likely to return relevant results that don't necessarily have the keywords you put in. Because instead of it just doing a keyword search, it's trying to understand what are you looking for and then present what you're looking for, whether you're doing a good job of asking for it or not. So that's interesting. Litigation analytics is a little bit weird and scary. So there's a company called Lex Machina, I think is how you pronounce that. And what it does is it takes the ways that judges, for the most parts, have ruled in the past, and it tries to figure out, given whatever motion or whatever it is that you're going to bring before the court, how likely it is to succeed. So I'm going to bring a certain type of motion to this judge. Does this judge like these motions? If so, the software might tell me, yeah, go ahead and file this motion, you're likely to win. If the judge hates these motions and always denies them, the software might say, look, this kind of judge is not the kind of judge who's going to grant this motion. So this, I think, is really interesting, and it's great for, representing your client's interests, understanding whether or not your client is likely to win in a certain situation. I do think it's a little bit worrisome in that what it does is it's reinforcing whatever prejudices these judges have. So if there's a judge who always dismisses a bunch of motions and Lex Machina tells you your motion is going to lose before this judge, then what that means is that that judge is just not going to see those motions anymore. So it is what it is, though. There are arbitration analytics. These do the same thing, but for arbitrators. So a lot of times when you click I agree on one of those contracts that you did not read, it will make you agree to binding arbitration, which is where some third party decides who of you is right in the dispute and gets to decide what happens, who pays whom, for instance. This arbitration analytics is doing something similar. This arbitrator has a long history. Are you likely to get a fair hearing from this arbitrator? If the arbitrator, picks the corporation over the individual every single time, then as an individual, you may not want to go in front of that arbitrator. Other things, and this I think is going to be helpful, especially for solo practitioners, automated document creation. So contracts often, not just contracts, other legal documents, but especially contracts, a lot of times have the same types of provisions, the same types of language. And so these automated document creation programs will just ask you a couple of questions and then set up a contract that you can edit afterwards, but is supposed to be close to finish when you get there. So that makes drafting a contract that you're going to create for your client a little bit easier. Those are the developments that we have. Let me just look. So I got one more question. Will there be fewer paralegals in the future? It will be less humanities and legal practice. I don't know that there will be fewer paralegals in the future. What I would say is that a lot of what paralegals do, or at least more of what paralegals do, I think could be replaced with automation and with AI than what lawyers do, because a lot of what paralegals do is like filing, calendaring, things that are less strategic and more functional. So it may be that there are fewer paralegals in the future, yes, but I don't know that I have a window on that. So that is the end of our presentation. I've got some questions in the Q&A box, so let me answer those. And then I will tell you a little bit about LSATMax and send you on your way. Here's a good one. It comes with an apology that it's off topic, but I think this is a good question. So anonymous attendee asks, if you got in trouble as a juvenile, but you got your record expunged, would you still want to write an addendum to attach to applications? So here is what I would say. Law schools are going to ask you to disclose certain things. They may say any expunged record does not need to be disclosed. Anything that doesn't need to be disclosed, I think also doesn't need to be explained. Conversely, if they do want you to disclose it, even though it was expunged, then you should disclose it and you should write an addendum explaining it. So I'm sorry that's not an answer, but it's more about whether or not they require you, and each law school has different requirements. But here's what I would say if you are going to write an addendum. I very often think that an addendum, even though it is a description of a bad fact, can often be very helpful to your application if you do it the right way. Because what an addendum can show is a learning experience. So lots of people go to law school after they've gone to prison. And that's where they make the decision to go to law school. They get in trouble with the law, and then they decide that that's an industry that they can have a happy career in. So it is not the case, very much so, it is not the case that having a bad act on your record is just going to keep you out of law school. If you are still the same kind of person who commits bad acts, then they're not going to want you at their law school. So all of that is a long roundabout way of saying, here is what a good addendum looks like when you have a bad fact on your application. You explain the bad fact entirely. Schools are going to Google you. If there are facts that you leave out, they will find them if they are available. So it explains entirely without leaving anything out. And it also shows what steps you have taken and what lessons you have learned on the basis of that bad fact. And so if you say, look, I had X, Y, and Z in my history, but those led me to, volunteer, to do this, to do that, and now I have this life experience, then an addendum ends up being actually a positive piece of your application, because it shows that you have the ability to understand what's going wrong and to make adjustments. So I wouldn't be worried about an addendum, but the last thing I'll say is if they want you to disclose it, please disclose and add an addendum. Answer this one. Oops. So Mary asks, what is your opinion on having a master's before entering law school? I have one in public administration. I was wondering if you think it will increase my chances of acceptance, or do you think it wouldn't make a difference? I think it increases your chances of acceptance in this way, or this is how I would look at it. Law school admissions is kind of a two-step process. In the first step, in the first phase of law school admissions, law schools are going to look at your LSAT and your GPA, and they're largely going to decide whether or not you go in a yes, no, or a maybe pile on that basis. If you are like above the 75th percentile in LSAT and GPA at a school, you're probably going to get in regardless of what else is on your transcript or regardless of what else is on your resume. Conversely, if you are below the median in both LSAT and GPA, you are likely to get rejected from a school, even if you have great other things in your application. So in that first phase, having a master's of public administration, I don't think is going to help. Not least because your GPA is calculated entirely on your undergraduate class performance. That said, if you get into a maybe pile, then I think it is very, very useful. Especially a master's of public administration is right in the wheelhouse of law school. A lot of what you do in law school is relevant to public administration. You learn how the laws work, you learn how agencies administer the laws, you learn how Congress or legislatures write the laws. So I do think it will be very useful and it will be very attractive to law schools in that second phase. All right, Samantha says, sort of off topic, but you mentioned being in patent law. I'm very interested in practicing IP law, but have not heard so great things about this area. What is your opinion on IP? Wow, so I'm actually really the wrong person to ask. I did practice patent law for about 2 years, but the reason I practiced patent law is, like I was talking about earlier, I was looking to be a district attorney and there were no jobs available. So I had studied criminal law, and because I needed a job and I knew someone who knew someone, I ended up doing patent law. I think patent law can be fascinating if you have a tech background. I do not have a tech background, so for me, it was very confusing. We were also, and I'm not going to get into it because this is like a 20-minute conversation, but the firm that I worked for was what is known as a patent troll. If you don't know what it is, look it up, but it's basically a legal but unethical way to use the patent law system to make money. So if you're asking what is it like to be a patent troll, I wouldn't recommend being a patent troll. But there are other areas of IP that I think people are very happy with. Trademark law, copyright law, those are also intellectual property, and you don't need a tech background to do those, or tech background is irrelevant. I wish I had had like a better experience, but again, I think I'm kind of the wrong person to ask. Any chance of more ABA approved online law schools in 2022? Yeah, I think there are very few right now. I think like, is it Syracuse, I think is one, has an approved online law school. I have not heard of any more approved online law school options. Although I would think after the pandemic, if the ABA wants to continue to be relevant, they will start approving more online law school programs. Again, law is something that you can do online. And I think in this past year, they proved that law school is also something you can do online. I've not heard of that, but I would not be surprised if it's coming. Do you know if pets can be in your room during your LSAT? I will have my dog in my house and I'm worried that if I lock him in another room, I will be distracted if he whines or cries. Gosh, I don't know the answer to that question. I wish I did. You can't have other people in the room with you. But I guess what I'd also say is that, I think what they require is that the room be quiet. So I don't know if having the door open, is your dog just going to like wander in and wander out and not bother you? If that's the kind of dog you have, then sure. If your dog is going to interrupt and like, jump up on your lap and get in your way, then I would think maybe you might want to drop your dog off with someone else before you take the exam. That's probably what I would do. So is there a webinar that will show what is the appropriate way to answer questions that require an addendum on your application? I don't know that we will have a webinar specifically on that topic. We have talked about addenda in general in our law school admissions presentation, which we very often give. But that's a very specific question. What I would say is just, hopefully the questions asking for disclosures are clear, And either the disclosure applies to you and you know it applies to you, or it doesn't apply to you. If they ask you for a disclosure and say you may write an addendum, I would write the addendum. So here's a question. Is it good to apply directly after finishing your undergraduate degree? And if I studied law degree in a different country and then apply for JD, would it be good? I think it's fine to apply directly after undergrad. Plenty of people, have a summer between their senior year of undergrad and their 1 year of law school and just go immediately. Lots of people take lots of time afterward. And I think law schools want to see that you are moving toward being a lawyer in some sense. But I don't think it really matters necessarily how you're doing that. If you went and got a law degree in a different country, especially depending upon what the system is, I don't know that it would be very useful here. Like, for instance, most countries in continental Europe, for instance, have or at least in some venues, have a different legal system on a fundamental level than we do. So we use the adversarial system, which is where kind of lawyers run a trial and a judge is just a referee. They have, or at least some European countries have, the inquisitorial system, where the judge runs the trial and the lawyers kind of work for the judge in a sense. So just learning a lot about different law, I don't know, will be so helpful. What I would say is that if you want to practice law in the United States, I don't think it would be a good use of your time to go get a law degree somewhere else and then come to the United States and get another law degree. I would just get one here. All right, should transfer students or students who drastically change their majors explain their transcripts in addendums? Well, if you're changing your major, it is very likely, or I would think it would be likely, to be explained somehow in your personal statement, because your personal statement is about, how did I get to where I am and why am I a good choice for law school? So what I would think is that if you had some kind of, a lot of people are pre-med and they're like, I hate this, I can't do math. And so they end up going to poli-sci or some other law school feeder major. So I do think you might want to put it in there. If you had bad grades, then yeah, I would write an addendum. But an addendum is about a bad fact. And just transferring or changing your major is not a bad fact. So if you did fine in your classes before and you just decided that that wasn't for you, then no, I wouldn't write an addendum. But if you did have bad grades, then yes, I would write an addendum. So Evan asked, what do you need to do if you're an older applicant, if you have been out of school for 10 years? The process is mostly the same. What you have to do to have a full law school application, you need to have an LSAT score, you need to have undergraduate transcripts, you generally need to have at least 2 letters of recommendation, a personal statement, and a resume. All of those things, with the exception of the letters of recommendation, really don't change depending upon how long you've been out of school. The thing about letters of recommendation is that law schools understand that if you've been out of school for 5 years or more, you're unlikely to have a good relationship with undergraduate professors who can write you letters of recommendation. So what that means is that somebody at your stage of life could likely apply to law school and have letters of recommendation from colleagues, ideally people who have supervised you, rather than professors. But otherwise, the process will be the same. This is a good question. Is it beneficial to attend a non-ABA approved law school? What I would say is you should be very, very careful with non-ABA approved law schools, because most law schools, if they were doing a good job of educating people to be lawyers, would get ABA accreditations. I don't want to say that every school that is not ABA accredited is a money hole, but a lot of these schools get people to take out loans and give them money, and then the people who go to those schools never end up being lawyers. So a lot of these schools have high dropout rates. A lot of them have low bar passage rates. So people are spending 3 years in law school, getting themselves in debt and not passing the bar exam. A lot of them have low job placement rates, even for the ones where people are passing the bar exam. So what I would say is that for any one of these schools, just have a look at bar passage rate, graduation rate, and employment rate. Is this school turning people into lawyers or not? If it's not, don't go. If it is, it might be okay. But the thing is, you know you're getting a quality education out of an ABA-approved law school. I'm not sure with the other ones. Let's see. Teacher asks, do you think there is a high demand for public legal aid lawyers? It is a, I think, fairly solid sized industry in the law. Is there high demand? I mean, the problem with public legal aid or with public interest law in general is that, and if you're talking about like a non-governmental organization, you know, like I worked for BetSetic, which did wage and hour law and landlord-tenant law and elder law. There's things like the ACLU or Amnesty International. And the thing is, these organizations all survive on donations. And so there's demand when they have money, but if they don't have money, then they can't pay their lawyers. And the lawyers at those public interest jobs, and I don't want to discourage you from going into public interest, but they tend to make less money than people do in either government or private law. There are a lot of those positions out there. So I would say, yes, there is demand. I think you just have to be realistic about, you know, the amount of money you're going to make, the market that you live in. But it is a noble profession. Let's see. I think we're just about to run out of time. Let me answer maybe one more question. Let's see. So Christopher asks, this will be the last question. Christopher asks, in what cases do you think paralegal experience can improve an application? I think paralegal experience shows that you understand what you are getting yourself into by going to law school. A lot of people see the law on TV and they're like, that looks cool, and I want to go to law school, and they really don't have any legal experience and they don't really understand what it's like to be in the legal field. And I think law schools are a little bit reticent when they get applications from people who clearly don't understand what it's like to be a lawyer, who have this kind of like fantasy idea of what it's like to be a lawyer. The fact that you are a paralegal means that you have worked in a law firm and that you've done the nuts and bolts work of the law and that you've seen how it works. So I do think it's very useful, but what I would say is that I don't think it's the kind of thing, a lot of people say, should I go get a paralegal degree in order to make myself more attractive to law school? I think that's probably taking a lot of time and money out of your life that is not useful. But if you have that experience, I think it is very useful experience. So yes, I would put that on your application. And again, what I think the law schools are thinking about when they look at it is that this person knows what the law is like. They know what they're getting themselves into, and we can be sure that they have the dedication to see it through, knowing what they're getting themselves into. All right, that is the end of our time here. So let me just check the chat box. I think I got the questions that were over there. I want to thank you for coming out today. I hope today's presentation was useful for you, and I hope to see some of you in the LSATMax course soon. But regardless, I just want to wish all of you the best of luck on the remainder of your undergraduate career, on the LSAT, on law school. Take care, be well, and do well on the LSAT. See you soon.